Hello. Next week, as we celebrate Martin Luther King Day, we will be reminded that Dr. King included housing equality as one of the goals of his life's work. So we are pleased to present this webinar on the history of restrictive covenants in California. Long before the United States Supreme Court's 1948 decision in Shelley versus Kramer, the enforceability of restrictive covenants was litigated in California, beginning in the 19th century. Bob Wolfe traces that history for us. Bob served for nearly 20 years as a senior judicial attorney for the California Court of Appeal. Today, he's an appellate attorney, a member of the board of the California Supreme Court Historical Society, and a first-rate legal historian. Bob's telling of the legal history of restrictive covenants embraces the case of Bruce's Beach, which was much in the news in recent years. Los Angeles County Supervisor Janice Hahn's family has a close connection to that story, and we're delighted to have Supervisor Hahn tell us about that later in this webinar. The California Supreme Court Historical Society thanks its co-sponsors of this webinar: the Ninth Judicial Circuit Historical Society, the U.S. District Court for the Northern District of California Historical Society, the Los Angeles County Bar Association, the Bar Association of San Francisco, and the Alameda County Bar Association. MCLE certificates, including 1 hour in the elimination of bias category, will be emailed to those of you who have registered for credit. And if you have questions for Bob, please put them in the chat box. He will address as many as time allows. Bob?
Welcome. I'm Bob Wolfe, a lawyer and occasional leader of legal history walking tours. Today, we're going to explore how and why housing inequality continues to plague California. California courts played a leading role, first in enforcing racially restrictive covenants, and then in trying to limit their pernicious after effects. More litigation occurred here, particularly in LA County, than anywhere else. There's a surprising reason for this. A cadre of dedicated, skilled attorneys, principally but not exclusively people of color, who devoted their legal careers to fighting housing discrimination. A few procedural notes. The stories are complex, and our time is short. Context and nuance may be lost. Your handout contains the pertinent cases. An MCLE link will be provided later in the chat. Please be sure to mute yourselves to eliminate background noise. Finally, a note about language. The images you'll be seeing display terminology in use at the time, not what is acceptable today. They are for historical purposes only. Thanks in advance for bearing with me. We begin in downtown Ventura at a building, originally Gandolfo's, which still stands today. You can see the historic marker on the bottom of your screen. In 1877, Alex Gandolfo, an Italian immigrant, opened a general merchandise and grocery store in the building. Nearby was a flourishing Chinese community, China Alley, of about 200 people. Gandolfo sold the next door property to Fridolin Hartmann, who proceeded to lease it to Chinese Americans, Fong Yet and Sam Choi. Gandolfo apparently feared the competition. In 1890, he sued Hartmann based on a pre-existing racially restrictive covenant against renting the property, quote, to a Chinaman or Chinamen, close quote. The suit ended up in federal court in downtown LA with District Judge Erskine Ross, who formerly had sat as an associate justice on the California Supreme Court. Judge Ross issued his published opinion in 1892. The result is amazing, holding that judicial enforcement of the restrictive covenant was state action and would unconstitutionally discriminate against the Chinese tenants in violation of the 14th Amendment. Judge Ross went on to a distinguished career on the Ninth Circuit, where he served until 1925. We'll see whether his decision, Gandolfo versus Hartman, had as long-lasting an impact. There were other promising signs. The 1910 census showed that in LA, 36% of African Americans owned their own homes, compared to only 2.4% in New York City. 3 years later, in May 1913, NAACP founder W.E.B. Du Bois had a triumphant tour to the region, lecturing at Occidental College, Pomona College, and USC. As Du Bois wrote in The Crisis, quote, "Los Angeles is wonderful. Nowhere in the U.S. is the Negro so well and beautifully housed. Here is an aggressive and hopeful group." Close quote. Du Bois' remarks found their way in a real estate ad in The Liberator, an influential African American newspaper published by Jefferson Edmonds, also a real estate agent. The ad concluded, quote, "Now is the time to buy choice real estate in this matchless country," close quote. One person who took Edmonds' advice was Homer Garrett, an African American police officer for the LAPD. In December 1915, Homer and his wife Pearl bought a house in the Title Guarantee Company's Angeles Park tract in South LA. Pictured is a postcard which Garrett wrote several months later from his new home. I searched for historic newspaper references to Homer Garrett. Pictured are just a few of the results. He stopped an arsonist, raided a gambling den, captured an armed gunman, and prevented a train wreck. He certainly didn't have a desk job. Interestingly, none of the articles mentioned Garrett's race. The Garretts befriended a couple, Hattie and John Hahn, who had just moved to the same neighborhood from Canada. John Hahn died a few months later, leaving a pregnant Hattie with 7 boys to raise. The youngest son, Kenny, went on to serve for some 40 years as an LA County supervisor. Kenny later praised the Garretts as, quote, "the first to offer friendship to the Hahn family," close quote. Even modest wage earners could afford to be homeowners back then. A janitor, Alfred Gary, and his wife Ellen bought a relatively new house in the Kendallsbury tract in South LA. The Garys, who were African American, did not buy the home directly from the developer, the LA Investment Company. The original owner, a white man, sold it to the Garys before moving on to Van Nuys. The house, pictured, is still standing today. Around the same time as the Garretts and Garys became homeowners, an enterprising couple, Willa and Charles Bruce, built a beach resort for African Americans in nearby Manhattan Beach. The resort soon expanded to 3 buildings, including a dance hall, cafe, and lodgings. It became a popular weekend destination, easily reachable by the red car. The photo in the bottom middle is of 23-year-old Virginia Edmonds, the daughter-in-law of Liberator publisher and real estate promoter Jefferson Edmonds. But this all may have been a fool's paradise. Up in Oakland, a new development, Rockridge Park, gained phenomenal success by trumpeting its availability only to whites. Its racist ads appeared in mainstream newspapers like the San Francisco Call, San Francisco Examiner, and the Oakland Tribune. To quote from one, "There are restrictions in this tract which do not exist elsewhere in Alameda County. Only one house on a lot, no flats or apartments, no cheap shacks, no Japanese, Chinese, or Negroes." Other developers eyeing the successful Rock Ridge Park experience, inserted restrictive covenants into their deeds. Regrettably, this included the deeds for both the Garretts and the Garys. The covenants are reprinted on your screen. The title guarantee covenant, for example, prohibited the sale or resale, quote, to any person of African, Chinese, or Japanese descent, close quote. The remedy? In the event of a breach, the covenants called for forfeiture. The property would revert back to the original grantor without compensation. That's how the Garretts and the Garys found themselves as targets in separate lawsuits to give their homes back to the original developers. Fortunately, the Garretts had some high-powered legal help. They retained attorney Willis O. Tyler to defend them. He's pictured on the right of your screen. Tyler had graduated from Harvard Law School in 1908 and specialized in property law. Tyler's offices were located at 2nd and Spring Street in the heart of downtown LA. Tyler demurred to the title guarantee complaint, relying on Judge Ross's published decision in Gandolfo about state action and the 14th Amendment. Pictured on the top left are Tyler's moving papers, including his discussion of Gandolfo. Superior Court Judge John W. Schenck, citing Gandolfo, dismissed the complaint. Title guarantee appealed. In July 1919, the Court of Appeal ruled in the Garretts' favor, but for a different reason. It bought Willis Tyler's backup argument, not about race, but about capitalism and the public policy favoring the free alienability of property. According to the court, quote, the free and liberal circulation of property is one of the inherent rights of a free people, close quote. The bottom line, the Garretts got to stay in their house and the restrictive covenant was struck down. The case made the front page of the LA Times. Quote, sale to Negro is held valid, close quote. Backlash to the Garrett decision was intense. White homeowners held a mass meeting to raise funds in what the LA Times called a race restriction war. The homeowners decided to use the LA Investment Company's case against Alfred and Ellen Gary as a test vehicle. They convinced the California Supreme Court to grant a hearing from a lower court decision favoring the Garys. Would the California Supreme Court affirm or reverse the Garrett precedent? The California Supreme Court issued its decision in Gary in December 1919. The court affirmed what it called the, quote, scholarly, close quote, Garrett precedent. Like the Garretts, the Garys were legally entitled to buy their house on West 51st Street. But that was not the end of the story. There was a separate covenant in the LA Investment Company's deed, a restrictive covenant against occupancy by non-whites. And that restrictive covenant was still enforceable because it did not involve the alienability of property. The net effect? The Garys were allowed to buy the house on West 51st Street, but not to live in it. Their occupancy breached the restrictive covenant and triggered the forfeiture clause. A horrible result. Look at the opinion's author, Olney, J. That's Justice Warren Olney Jr., who briefly served on the California Supreme Court for several years before resigning to go into private practice. Justice Olney's name may sound familiar. His grandson, Warren Olney IV, is a highly regarded public radio broadcast journalist, commentator, and podcaster. Until I contacted him, he had not been aware of his grandfather's authorship of Gary. Justice Olney reached this decision without the benefit of any briefing from the Garys. I recently discovered why. Alfred Gary died in 1918, well before his case was argued and decided. He was so marginalized that the Supreme Court never acknowledged his death and likely did not even know about it. You can see his death certificate on your screen. The upshot, Alfred's widow, Ellen, lost the home. The 1920 US Census places her at age 58 in a room in a boarding house. One large developer, the Jantz Corporation, routinely inserted restrictive covenants into its Southern California subdivisions. Relying on one such covenant, Jantz sued Betty and Jesse Walling, an African-American couple, to prevent them from living in a house they were in the process of buying in East LA. Jantz's most prominent development is Westwood Village, where it donated 385 acres for UCLA's new home. The Jantz Steps, adjacent to Royce Hall, are named in the company's honor. Ironically, it was from the Jantz Steps where Martin Luther King gave a speech in 1965 entitled, "Segregation Must Die." The Wallings had the foresight to retain Willis Tyler to defend them against the lawsuit by the Jantz Investment Company. Tyler convinced the California Supreme Court to take up the case, arguing that its earlier decision in Gary was poorly reasoned, largely because the court only heard from one side. Willis Tyler argued law, logic, and public policy. Why deny places to live to such a large segment of the working population? Quote, I own a book but cannot read it at all. I have an automobile but can only let or hire it to another. How can it be said that a Negro has property when he is denied its actual use? Close quote. The California Supreme Court's response? Stare decisis. Quote, it becomes unnecessary and inadvisable to devote much time or thought to a consideration of appellant's legal points. The court held, we've already considered this. In 1924, the National Association of Realtors required its members to engage in so-called racial steering. It became an ethical violation for realtors to sell property to any racial or ethnic group whose presence would be perceived as reducing property values. On the bottom right is a newspaper ad for Eagle Rock, touting the fact that its residents are, quote, all of the white or Caucasian race, close quote. In 1926, in Corrigan v. Buckley, the U.S. Supreme Court dismissed a constitutional challenge to racial covenants for lack of a federal issue. Even death could not free non-whites from the clutch of a restrictive covenant against occupancy. Remember Homer Garrett? Homer's sister-in-law, Lily Garrett, happened to be buried in Glendale's Forest Lawn Cemetery. Her family purchased an adjoining lot when Lily's sister Hattie died in 1922. But, unknown to the family, Forest Lawn had subsequently adopted a restrictive covenant against interment of, quote, any body or any body's ashes other than of a human being of the Caucasian race, close quote. A day before the scheduled funeral, Forest Lawn discovered Hattie's race from her death certificate and sued to cancel the contract. Willis Tyler represented the family at trial and on appeal, but to no avail. Both Hattie and Lily had to be reinterred in Rosedale Cemetery, which made no distinction between the color of the souls of the deceased. There was no restrictive covenant against the use of the Bruce's Beach Resort in Manhattan Beach by African Americans. But white neighbors, fearing what they called an invasion, grew to resent the resort's growing popularity. They posted no trespassing signs to block beach access by blacks. They let air out of some guests' tires. In November 1924, the Manhattan Beach City Council filed an eminent domain lawsuit to condemn the property and some 30 adjoining unimproved lots, ostensibly to build a park. The Bruces, represented by Willis Tyler, argued the city's actions were motivated by racial bias. They challenged the fact of the taking and the amount the city was willing to pay. The Bruces lost on both accounts, being awarded only $14,500 of their requested $70,000. They turned over their property in 1927. You can see what the city of Manhattan Beach did with the Bruce's land. Here's a picture of the so-called park in 1950, some 20 years after the condemnation. While the Bruce's buildings had been torn down, only sand dunes remained. The park was not developed for about another decade. Until now, the plaintiffs in restrictive covenant cases have all been the original developers who created and recorded the deeds. But these covenants often had time limits, or the developers were no longer available to file suit. To maintain segregated neighborhoods, homeowners tried something new. They attempted to create new neighborhood covenants against non-whites, which they recorded on their individual properties. Could these contracts be made to run with the land against subsequent non-white purchasers? In 1926, attorney Willis Tyler convinced Superior Court Judge W.C. Duran to rule that the answer was no. Tragically, 2 years later, the California Supreme Court disagreed. It directed Judge Duran to issue an injunction preventing Adolph and Maddie Kinchlow from living in their house because of a neighborhood covenant that had been recorded with the deed. That significant case, Waite versus Petit, is reprinted in your handout. Segregated neighborhoods also were maintained through a practice which came to be known as redlining. A New Deal mortgage insurance program graded different urban areas by supposed risk of default. The red or hazardous sections coincided with areas where non-whites happened to live, making it virtually impossible for them to secure federally insured mortgages in such redlined areas. Pictured on your screen are redlining maps in LA, the Bay Area, and San Diego. Here's some examples of the destructive impact of the California Supreme Court's decision in Waite versus Petit. In Berkeley, 16 residents secured a permanent injunction to force out Dr. DeWitt Buckingham, an African-American physician at Kaiser Permanente, and his family. As Berkeley's mayor pointed out, John Wilkes Booth and Al Capone could live in the Claremont neighborhood, but not George Washington Carver, Mahatma Gandhi, or Dr. Buckingham. In West Hollywood, 5 neighbors relied on a neighborhood covenant against occupancy by non-whites to sue the Crocker family. The Crockers had been living in their Westbourne Drive house for more than 5 years. While husband Harry Crocker was French-Canadian, wife Isabel Crocker was 3/4 Native American from the Iroquois tribe. Hence, Judge Reuben Schmidt ruled Harry could stay in the house, but Isabel and the couple's 3 daughters had to go. Perhaps the most egregious example of evil arises from the experience of Henry and Anna Laws, a Black couple who purchased vacant land in what was then the largely white community of Watts. After 13 years, the Laws saved enough money to build a 2-bedroom, 1-bath home. Neighbors and a realtor sued to enforce a restrictive covenant. The case came to trial during World War II. The Laws' 2 sons were in the military, serving in the South Pacific. Henry worked in a defense plant. Their daughter and grandchildren also lived in the house. A Superior Court judge ordered the Laws to move. They refused to do so. They owned the house, and housing was very short during the war. Sheriff's deputies arrested Henry, Anna, and daughter-in-law Pauletta Laws Spears and actually jailed them. The NAACP bailed the Laws out after 3 days in jail while their case was pending on appeal. Not all restrictive covenant cases ended with as bleak a result as the Buckingham, Crocker, and Laws cases. Willis Tyler was joined in the litigation struggle by Loren Miller, a highly talented African-American journalist and attorney who was admitted to the California State Bar in 1933. Loren Miller embarked on a lifelong campaign to resist restrictive covenants with every possible legal tool. Willis Tyler and Loren Miller deftly used equitable doctrines like changed circumstances, as where non-whites already had moved into substantial sections of a previously segregated neighborhood, to score some limited successes. Still, the task was formidable. As depicted on the bottom right of your screen, Loren Miller became involved in lawsuits affecting over 1,000 parcels of property. In Fairchild versus Raines, Willis Tyler and Loren Miller teamed up in the California Supreme Court to reverse an adverse ruling against a Pasadena African-American family based on the changed circumstances doctrine. What is most noteworthy is the concurring opinion by Justice Roger Traynor. Justice Traynor cited both public policy and the long overlooked 1892 opinion of Judge Erskine Ross in Gandolfo. Where, Justice Traynor asked, are African-American migrants who we need to work on our wartime defense industries to live? Even before Fairchild, an Orange County Superior Court case involving a Latino family led the way. Racially restrictive covenants in Fullerton's Sunnyside neighborhood barred, quote, any Mexicans or persons other than of the Caucasian race, close quote, from occupying homes. White neighbors thereby sued to force Alex and Esther Bernal and their 2 young girls to move from their newly purchased home. While Alex Bernal was born in Riverside County, both Esther and Alex's mother hailed from Mexico. The trial judge, Albert Ross, ruled that these restrictive covenants violated the 14th Amendment. The Bernal's attorney, David Marcus, went on to successfully challenge the forced segregation of Mexican-American students in another landmark case, Mendez versus Westminster School District. Loren Miller teamed up with Willis Tyler to represent Oscar-winning Gone with the Wind actress Hattie McDaniel in defending her right to live in a house she owned in the Sugar Hill, West Adams section of Los Angeles. 8 white Sugar Hill residents had sued to have McDaniel and some of her neighbors, including famed singer Ethel Waters, evicted from their homes based on restrictive covenants against occupancy. On December 7th, 1945, Judge Thurman Clark went to the heart of what he called the real issue, the, quote, full rights guaranteed under the 14th Amendment to the federal Constitution, close quote. Hattie McDaniel's house is still standing, although much of the Sugar Hill neighborhood has been destroyed by construction of the Santa Monica Freeway. In a separate Superior Court case, Lauren Miller represented defendants Frank and Artoria Dry against efforts to evict them and their 5 children from their home in LA's Country Club Park neighborhood. The plaintiffs, Pastor W. Clarence Wright of the Wilshire Presbyterian Church, who lived across the street, and 8 other white neighbors, argued the Drys were in violation of a racially restrictive covenant against occupancy. Frank Dry was a veteran of both World War I and World War II and was discharged with the rank of a major. Artoria Dry was a teacher. They had saved up money for 26 years in order to buy their house. The case came before then Superior Court Judge Stanley Mosk. In October 1947, Mosk dismissed the lawsuit as inconsistent with the 14th Amendment. Quote, there is no more reprehensible un-American activity than to attempt to deprive persons of their own homes on a master race theory, close quote, he wrote. At the time, Mosk was only a Superior Court judge, so his ruling, like Judge Thurman Clark's, only bound the litigants before him. Artoria Dry lived in her house on South Arlington Street until she died in 2004 at the age of 106. In May 1948, Lauren Miller moved onto the national stage when he joined with Thurgood Marshall to argue the landmark case, Shelley versus Kramer, which finally held that private restrictive covenants could not be enforced by the courts because they violated the 14th Amendment of the United States Constitution. Within weeks, the California Supreme Court followed Shelley versus Kramer to reverse many of the injunctions we previously discussed, including those against a Berkeley physician, Dr. DeWitt Buckingham, and the contempt convictions of Henry and Anna Laws. Exclusionary groups tried an end run around Shelley by suing for damages for breach of contract rather than for injunctive relief. Leola Jackson was a white South LA homeowner who breached a neighborhood covenant when she sold her home on West 60th Street to an African-American couple, the Smalleys, in 1950. Jackson hired Lauren Miller to represent her. Citing Gandolfo as well as Shelley, the California Court of Appeal held that any judicial enforcement of the covenant, whether in law or equity, violated the 14th Amendment. The U.S. Supreme Court granted cert because of conflicting decisions in other states and agreed with the holding of the California Court of Appeal. California's alien land law, first enacted by the legislature in 1913 and then toughened up in 1920, prohibited first-generation Japanese immigrants from owning land in California or even entering into long-term leases. USC law grad Sei Fuji, class of 1911, resolved to overturn this racist law. Fuji was no stranger to invidious discrimination. Despite his USC law degree, he never was permitted as a Japanese immigrant to become a US citizen, and California law only extended bar memberships to persons eligible to become attorneys. He turned to journalism instead. In 1948, Fuji purchased a small lot in East LA for $200 and filed suit to clear title so that he could build a home there. The California Supreme Court issued its opinion in Fuji's case in 1952, finding the alien land law to be an unconstitutional violation of the 14th Amendment. According to Chief Justice Phil Gibson, quote, there can be no justification for a classification which operates to withhold property rights from some aliens solely because they are Japanese and not French or Italian, close quote. In 1954, federal law was amended to allow Japanese-born residents to become citizens. Fuji, then age 72, became a citizen, but died of a heart attack 51 days later. In 2017, the California Supreme Court posthumously admitted Fuji to the state bar. Even after Shelley, the San Francisco Housing Authority continued to target its public housing projects by race to maintain the same racial composition as the neighborhoods in which its projects were located. As a result, the authority rejected the application of plaintiff Maddie Banks, an otherwise qualified African American woman, to live in a newly opened project in North Beach because the project was designed for Italian American families. The California Court of Appeal found the agency's neighborhood pattern policies to be unconstitutional. Maddie Banks' attorney was Lauren Miller. Shelley was an important step towards racial justice in housing, but it certainly was not a panacea. The U.S. Supreme Court only barred judicial enforcement of racially restrictive covenants, but expressly held that the covenants themselves were perfectly legal. The, quote, exclusive and restrictive, close quote, sign on the lower left is from the Sunkissed Gardens housing tract in September 1950, 2 years after Shelley. That was located in the Torrance area of LA. The Forest Knolls development in San Francisco similarly refused to allow Blacks to view its model homes, spurring the sit-in strike, which is pictured on your screen. Social enforcement of racial and ethnic restrictions came to play as much force as legal action by making new residents feel very uncomfortable for breaking existing demographic norms. In 1952, Sing Sheng, a Pan Am worker originally from Shanghai, and his Missouri-born pregnant wife, Grace, bought a house in an all-white South San Francisco neighborhood. In response to threats and bullying, Sheng naively offered to put his continued presence up to a neighborhood vote. He thought wrong. The neighbors voted him out, drawing national attention and considerable sympathy. The Shengs had to move further down the peninsula. Even beloved baseball superstar Willie Mays was not immune to racism when he attempted to buy a house near San Francisco's exclusive St. Francis Wood district following the New York Giants' 1957 relocation to San Francisco. Reacting to neighborhood pressure, the seller, a well-known home builder, backed out of the deal, but ultimately had a change of heart. The Mays never were comfortable with their home and soon sold it and returned to live in New York. Racial steering and so-called gentlemen's agreements by realtors are widely understood to have been the cause of the exclusion of Jews in elite neighborhoods like Hancock Park, Palos Verdes, San Marino, and La Jolla. La Jolla real estate agents made concerted efforts not to sell to Jews, so much so that Roger Revelle, often referred to as the father of UC San Diego, pointedly told the Realtors Association, quote, you can't have a university without having Jewish professors. You have to make up your mind whether you want a university or an anti-Semitic covenant. You can't have both, close quote. In the wake of the 1958 election of Democratic Governor Pat Brown, the California legislature passed landmark civil rights legislation prohibiting racial discrimination of, quote, all business establishments of any kind whatsoever, close quote. It was unclear whether the Unruh Civil Rights Act applied to commercial housing tracts. And so, the Poppy Development Company refused to sell one of its new homes to an African-American couple, Mr. and Mrs. Seaborn Burks. The Burks sued and secured a California Supreme Court ruling that all and of every kind meant precisely that, including real estate businesses. Torrance builder Don Wilson Company, the fourth largest home builder in the U.S., became the subject of picketing and multiple sit-ins based on reports of discriminatory and rude practices against people of color by its sale agents. The Court of Appeal affirmed then Attorney General Stanley Mosk's standing to enforce the law on the public's behalf. But private housing sales still appeared to be uncovered by the civil rights laws. 1960 LA was the most segregated city in the state. 94% of the African American population lived in the south central part of the city. And in the Bay Area, of the 335,000 homes built in the 6 San Francisco Bay counties in the decade of the 1950s, only 3,000 were sold to non-white buyers. In 1963, at the urging of Governor Pat Brown and Assembly Speaker Jess Unruh, the legislature passed the landmark Rumford Fair Housing Act, prohibiting any form of discrimination in the sale, leasing, or renting of any real estate within the state. Reaction to the Rumford Act, particularly by the real estate lobby, was swift. An initiative, Proposition 14, placed a constitutional amendment on the November 1964 ballot to give absolute discretion to, quote, rent or sell your property to whom you choose, close quote. Prop 14 passed by a landslide by more than 65% of the vote, a margin of more than 2 million votes. And that was the same year that Democratic President Lyndon Baines Johnson decisively beat Barry Goldwater in the country and in the state of California. Prop 14's effect was immediate, as can be seen in the 3 separate cases that are depicted on your screen. Most notably, in Santa Ana, a landlord, Neil Reitman, refused to rent an apartment to Lincoln and Dottie Mulkey simply because they were African American. The case was set to be heard by Orange County Superior Court Judge Stephen Tamura, but Reitman's attorney challenged his impartiality, quote, because he is a member of a minority group, close quote, namely Asian Americans. Judge Tamura stepped down, and his successor granted summary judgment for Reitman and against the Mulkeys. In like fashion, the Barrington Plaza, a new luxury apartment complex on LA's west side, was found to have lawfully refused to rent an apartment to an African-American physician, Dr. Thomas Roy Payton, because he, quote, couldn't afford it. Apparently, Dr. Payton's offer to pay 1 year's rent in advance didn't suffice to convince the management company of his economic stability. The California Supreme Court granted petitions for hearing in all 3 of these Prop 14 cases. In a 5-2 ruling, the California Supreme Court held the initiative violated the Equal Protection Clause by providing Californians with a constitutional right to discriminate, a form of state action against racial minority groups. The U.S. Supreme Court subsequently agreed with the California Supreme Court, but by a much narrower margin, a 5-4 vote. The 1968 Federal Fair Housing Act, signed into law by President Lyndon Johnson, made open housing a federal right and invalidated racially restrictive covenants nationwide. Let's explore what happened to some of the other people involved in the ongoing struggle for fair housing. Homer Garrett, our protagonist in the first legal decision to crack open the restrictive covenant barrier, went on to become a captain in the LAPD and head a detective bureau. He retired in 1939. In 1960, a public swimming pool in South Los Angeles was named in his honor. The Garretts are here pictured with LA County Supervisor Kenneth Hahn, who recounted his own family's close connections with the Garretts. Homer Garrett remained at his 59th Place house until he died in May 1965. In 1942, his son, Homer Garrett Jr., became the first African American officer on the California Highway Patrol. He decided to go to law school at night. He graduated number 1 in his class. Future LA Mayor Tom Bradley was number 2 and passed the California bar in 1960. He resigned from the Highway Patrol in 1963 and became a public defender. In 1973, then Governor Ronald Reagan appointed him to the municipal court. And the Loren Miller family. There are 3 generations who have now served on the bench as judges. Loren Miller, first appointed in 1964, who served until his death in 1967. His son, Loren Miller Jr., who served from 1975 until 1997, and his granddaughter, Judge Robin Miller Sloan, who is now sitting as a Superior Court judge. In 1970, the new Loren Miller Elementary School was opened to serve the educational needs of 1,300 children. The school celebrates Loren Miller's history and legacy. It was not until 2006 that the city of Manhattan Beach publicly acknowledged this chapter of its history by naming the area east of the beachfront property Bruce's Beach Park to recognize, quote, the greatest blemish in our history in the events of the 1920s at Bruce's Beach, close quote. Here's a picture taken in 2018 of the Bruce's descendants appearing at a family reunion at the city park. Just as County Supervisor Kenneth Hahn worked with the Homer Garrett family, so too his daughter, also County Supervisor Janice Hahn, has worked with the Bruce's family to redress what was taken from Willa and Charles Bruce. The suggested remedy? Transfer their beachfront lots back to the legal heirs. In September 2021, the California legislature unanimously passed enabling legislation to effectuate the transfer of the Bruce's Beach lots back to the Bruce family. SB 796 included legislative findings that Bruce's Beach was wrongfully taken and that its return would serve the public interest. Here, County Supervisor Janice Hahn dedicates a plaque at Bruce's Beach to detail its history. In July 2022, LA County officials handed over the deed to the property to the descendants of the Bruce family. In 2023, the Bruce family sold the property back to the county for $20 million to allow its continued use as a lifeguard training headquarters. Last year, the city of Manhattan Beach held a ceremony to formally apologize to the Bruce and other African American families for condemning their land in the 1920s for racially motivated reasons. I was fortunate to be among the many attendees who were present to acknowledge such actions and to commit to a future of respect, inclusion, and even hard conversations. I'm pictured in the photos far right with the baseball cap. The California Association of Realtors apologized as well and pledged to take concrete actions to address the imbalance in intergenerational wealth, particularly among African American families, that resulted from their past practices during the last century. And county recorders are now required to establish computer programs to identify and redact unlawful restrictive covenants from recorded property deeds and to maintain searchable records of what has been removed. Closing recap. I've long been bothered by the unknowns after the California Supreme Court ruled that Alfred and Ellen Gary violated a racially restrictive covenant against occupancy simply because they lived in their own home. We've heard about driving while black, but living while black? As previously mentioned, we now know that Alfred had died and that Ellen, at age 58, ended up living in a boarding house. What later happened to her? And who acquired her house? Thanks to the LA County Assessor's Office, we now know at least what happened to the house, if not to Ellen Gary. But the mystery only deepens. The new owner, Anna Leggett, was also an African American. Indeed, Anna Leggett, a chiropractor with her own practice, was a prominent member of the African American communities, as was the house, which was the site of many society events and frequently mentioned in the African American press. Anna Leggett lived there until her death in 1943. How was Anna Leggett able to stay in the house on 51st Street if Ellen Gary could not? Yet another unanswered paradox of history. We close on a positive note. Willis Tyler, a brilliant and heroic civil rights attorney by any measure, continued to make history even 3/4 of a century after his death. In September 2023, the intersection of 2nd and Spring Streets in the heart of LA's Civic Center and the location of his law offices was renamed in his honor as Willis O. Tyler Square.
Thank you to the California Supreme Court Historical Society and especially Bob Wolfe for organizing this great program about the history of restrictive covenants in California and for spotlighting Bruce's Beach. I know that earlier in the program you talked about my family's connection with Homer Garrett, the black police officer who fought back successfully against the restrictive covenants on the house he purchased and who lived down the street from my father and his family. But there is even an additional connection. Willis O. Tyler, the civil rights lawyer who represented Homer Garrett, also represented Willa and Charles Bruce. So while he might not have been able to save the Bruces from having their land taken from them in the 1920s, I think his work still ultimately helped return it to the Bruce family nearly 100 years later. By winning Homer Garrett's case, he created a ripple effect. I believe that my father's perspective on life was shaped by his early experiences growing up next to the Garretts. And on top of that, the Garretts helped my grandmother, Hattie Hahn, feed her family after my grandfather died unexpectedly. My father grew into a great leader and a civil rights champion and was reelected 10 times by a largely African American supervisorial district. I followed my father's footsteps to run for county supervisor and used the power of my office to return Bruce's Beach to the Bruce family. In Judge Mitchell Beckloff's decision upholding the return of Bruce's Beach, he said, "Righting a government wrong perpetuated in breach of our core and fundamental constitutional principles works to strengthen governmental integrity, represents accountability in government, and works to eliminate structural racism and bias." I think that quote is fitting for your discussion today. For decades, our government worked hand in hand with people who were white and privileged and powerful to uphold the status quo and prevent people of color from building wealth. There is still work that needs to be done to make up for those wrongs, but that work doesn't weaken our nation or our society, it strengthens it. I believe returning Bruce's Beach is the most important and impactful achievement of my career in public service, and I couldn't have done it without lawyers. Both Tom Fonan from the Los Angeles County Counsel's Department and George Featherly, who represented the Bruce family. I will leave you with this quote from Caruso School of Law professor Jeffrey Baker. "We are all committed to the dignity of all human beings and to the human rights that bring justice, equity, liberty, hope, and love to our communities. I believe they rest on the rule of law and fundamental forms of democracy which depend on lawyers." Thank you for your commitment to justice, equity, hope, and love. Keep up the good work.
Thank you, Supervisor Hahn, for your powerful words and for your equally powerful actions. Thanks also are due to Judge Barry Good and to the Society's Administrator, Chris Stockton, for organizing and promoting this program. And sorry to anyone who had technical difficulties today. In the time remaining, I'd like to address a few of your comments and questions, although I regret that I can't now get to all of them. I'm probably going to be writing an article about this later for one of the Society's publications. First, I've been asked why restrictive covenants came to be enforced in the early part of the 20th century and why the tide began to change in the 1940s. Based on other research which I've done, there's a link to this on page 2 of your handout. I believe that one of the reasons is the staggering success of D.W. Griffith's film Birth of a Nation, which had its world premiere here in LA on February 8, 1914. The film caused many whites to view African Americans as a threat to their personal safety and security and to seek refuge in segregated neighborhoods. More than anything else, World War II caused a marked shift in these racist attitudes, not only because of the prominence of African Americans as soldiers and workers in the war effort, but also because the war itself came to be seen as a fight for democracy and the rule of law. These indeed are the reasons given by jurists like Thurman Clark and Stanley Mosk, who struck down restrictive covenants in the cases before them. A second question that I've been asked is, what in your research caused you the greatest surprise? It's attorney Willis Tyler's eloquence. I've read thousands of legal briefs over the course of my legal career, but Tyler's words, which I read in the briefs in the LA County Law Library, literally jumped off the page. I'm glad that his advocacy is finally getting its due. A related anecdote, 2 weeks ago, I got a Facebook friend request from Judge Erskine Mayo Ross, complete with the same picture that you saw at the beginning of this Zoomcast. That's strange. Erskine Ross lived from 1845 to 1928. While he surely was ahead of his time on state action and the 14th Amendment back when he wrote the Gandolfo opinion, I doubt his foresight extends to social media. And who and how would someone know to link Judge Ross to me through Facebook? It's yet another disquieting mystery. Last, a question about housing discrimination in the Central Valley and other parts of the state. I received a link to a Superior Court complaint in a 1945 Fresno County case. The defendants there were Armenian Americans who were ensnared by a different kind of a restrictive covenant. And let me read it. It was against Asiatics, Mongolians, Hindus, Armenians, or any natives or descendants of the Turkish Empire, close quote. Ironically, these are people who came from the region of the Caucasus, from which the term Caucasian is derived. Which brings me to a larger point. If anything, this talk, which has focused primarily on published appellate cases, has understated the impact of restrictive covenants on marginalized and disfavored Californians. We should know more about the magnitude of the impact of restrictive covenants once housing deeds are digitized pursuant to the 2022 legislation, which is reprinted in your handout in AB 1466. As Supervisor Hahn mentioned, our necessary work to redress housing inequity in California has only begun. Again, my thanks to all of you for joining today, and have a good afternoon. Thanks again.